This is Bloomberg Law with June Grasso from Bloomberg Radio.
A growing number of lawmakers on both sides of the aisle are calling for the Justice Department to release all the files related to Jeffrey Epstein. This despite President Trump's efforts to downplay them, calling it a hoax and a scam.
It's all been a big hoax. It's perpetrated by the Democrats, and some stupid Republicans and foolish Republicans fall into the net. And so they try and do the Democrats' work.
Last Thursday, Trump authorized the Justice Department to seek the release of grand jury testimony from the Epstein prosecution after the Wall Street Journal published a story alleging that he once sent a suggestive birthday letter to Epstein. But some Republicans, like Tennessee Congressman Tim Burchett, are still saying it's not enough.
I think it's a start. I don't think we're ever going to get to the bottom of anything, all of it. This town doesn't give up its secrets very easy.
Joining me is former federal prosecutor Robert Mintz, a partner at McCarter English. Bob, so the Trump administration asked a federal judge to unseal the transcripts in the Epstein case. This is an unusual motion. Why go through the bother of making it? What information would you really be able to get from those transcripts?
Well, there's no question that the release of grand jury transcripts raises real privacy concerns about not only the victims, but even individuals whose names may have come up in connection with an investigation, but were never charged, would not have any opportunities to defend themselves if those names were released. The other thing about the grand jury testimony that's interesting is that typically the grand jury is used for the limited purpose of obtaining an indictment. Now, there are circumstances where prosecutors will use a grand jury as more of an investigative tool, and in that instance, you might have more witness testimony in front of a grand jury. But for the most part, when you're the prosecutor, the last thing you want to do is put a key witness in front of the grand jury because that testimony would then have to be turned over to the defense counsel at some point. So most of the time, all of the critical witness interviews take place outside of the grand jury, assuming those witnesses are cooperating, and they're done in front of an FBI agent or another investigative agent, and a report is prepared, but that's not grand jury material, and that's not the kind of information that will be released if a judge indeed decides to release these grand jury transcripts.
Even if they release transcripts of, let's say, an FBI agent's testimony to the grand jury, you wouldn't see, for example, the notes of witness interviews or photos, anything that's attached to that.
No, in fact, it's quite the opposite. When the FBI interviews a witness outside of the grand jury, they create a report commonly known as an FBI 302. And that is a detailed report of what a witness says during the course of an interview. But when a prosecutor presents his or her case to the grand jury, if they put an FBI agent on the stand, that testimony will be very focused and will be very summary in the sense that all the prosecutor is looking for is enough evidence to show a grand jury that there's probable cause that the crime has been committed and that there's enough evidence to move forward with the charges. So the reality is, as a prosecutor, you want to present as little information as you need in front of the grand jury in order to obtain that indictment. The other thing about grand jury testimony is that hearsay is admissible, so that agents routinely will go in to the grand jury in order to obtain an indictment and provide a summary of witness interviews. They don't have to provide all the details, and the witnesses themselves do not have to appear to present their testimony in order for the grand jury to rely on that testimony in deciding whether or not to return an indictment.
And Bob, talk a little bit about the importance of protecting grand jury secrecy.
So grand juries are covered by something called the Federal Rule of Criminal Procedure 6E. It's a rule that every federal prosecutor is extremely familiar with, and it prohibits an attorney from the government or anybody really who is aware of matters occurring before a grand jury from disclosing any of that information. In fact, when you represent a witness who goes to testify before the grand jury, as the lawyer, even you are not permitted to go inside the grand jury. Only the witnesses, and you can debrief your client after they come out because the witnesses themselves can talk about what their testimony was, but nobody else can talk about what goes on in the grand jury, not any of the grand jurors, and not any of the federal prosecutors. And there's good reason for that. The grand jury is an investigative tool. Information is presented to a grand jury that may not ever result in an indictment. Charges may never be brought. And the concept behind Rule 6E is that all of those proceedings are secret unless and until an indictment is returned by that grand jury. And it's done in order to preserve the privacy of victims and even the privacy of individuals who prosecutors may suspect have committed a crime, but ultimately, if they're never charged, the idea that it would be unfair to release damaging information about an individual who then never gets their day in court if they're never charged with a crime.
What are the reasons that the Attorney General is giving for unsealing the grand jury testimony?
Well, the Department of Justice filed a motion before Judge Richard Berman, who was the judge that was handling the Epstein case at the time that Mr. Epstein committed suicide. And the motion essentially said that disclosure of this grand jury testimony is necessary given the long-standing and legitimate public interest in the Jeffrey Epstein case. It's going to be interesting to see how the judge handles that request because there are many cases that are very high profile, of which there is long-standing and legitimate public interest, and typically a judge will not release that information. Now, in the Second Circuit, which is the Court of Appeals, where any decision made by the trial judge will ultimately end up, the law says judges have inherent authority to release grand jury materials in what's called special or exceptional circumstances. And what that really means is that it is up to the discretion of the judge whether or not to release this information, but it certainly suggests that it is done only in the most unusual of circumstances. And then, even if information is released, it would have to be heavily redacted. And by that, I mean that the names of victims and perhaps even the names of some individuals would be blacked out and not released to the public. So the reality is that this motion may take some time for the judge to decide, and then even if the judge decides to release that information, there may be parts of it that are blacked out and never released to the public. So we really don't know how critical this information ultimately will be, even if a judge decides to grant the government's motion.
There's also the fact that his co-defendant, Ghislaine Maxwell, is appealing her conviction to the Supreme Court, and the government acknowledged that in their papers, saying, while the government recognizes that Maxwell's case is currently pending before the Supreme Court, it nonetheless moves this court for relief due to the intense public scrutiny into this matter. So will the judge have to weigh, the possible impact on her case with the public interest?
Yes, you're absolutely right. As you said, Ghislaine Maxwell, who was the former girlfriend of Jeffrey Epstein, was convicted in 2021 on sex trafficking charges, and she's currently serving a 20-year sentence. But as you say, that conviction is going up on appeal, and the court will be mindful of her rights and will try to make sure that nothing that is released here ultimately could be prejudicial to her. So there's an awful lot for the court to weigh in the balancing act of trying to figure out what, if any, information should be released. And then I think the real interesting question is, even if the judge does grant this motion and release some of this grand jury information, just how critical will it be in terms of answering the questions that seem to be motivating the Department of Justice to file this motion for the release of grand jury testimony?
Some are suggesting a special counsel. Trump initially said, I have nothing to do with that. But then the press secretary said that Trump wouldn't recommend a special counsel. Could a special counsel get to the truth here?
Well, there could be another type of investigation into exactly what the Department of Justice did, because there's lots of evidence that was gathered during that investigation that is not going to be part of grand jury testimony. For example, there's videos, there's photographs, other recordings, there's text, there's emails. There's an enormous amount of information that was no doubt gathered by federal prosecutors during the course of this investigation. None of that information will be released based upon the government's motion. So there's lots of information that's still going to be out there. And I think the pressure is going to continue to mount to release more information. It is, I should say, a highly unusual circumstance here. It's highly unusual for the Attorney General of the United States to be asking a court to unseal grand jury testimony. And it's even more unusual for the President of the United States to be weighing in on that question. So we're in a circumstance here where there is not a lot of precedent to see how the courts may look at this information. Generally, the courts are reluctant to release this type of information given the privacy concerns that are at stake here and the concept that it's simply unfair to release the names of individuals who may have been caught up in an investigation but who were never ultimately charged with a crime.
Is filing to get the grand jury transcripts more of a distraction? Because the information that people seem to be looking for is not going to be found in grand jury transcripts, but rather in the files the Justice Department has.
Given the mounting public pressure to release information in connection with this investigation, the decision by the Department of Justice to seek the unsealing of the grand jury testimony is somewhat unusual because that testimony is going to be focused on building the case against Jeffrey Epstein and the case against Ghislaine Maxwell, and specifically on the conduct that formed the basis of the criminal charges against them, which means it's a narrowly focused investigation, and the grand jury testimony is likewise going to be narrowly focused on the evidence that they had to present to the grand jury in order to obtain those criminal charges. The remainder of the files are going to be much more far-reaching. They're likely to involve other individuals and perhaps other activity that never made its way into either of those indictments. But then you raise the question of bringing in the names of victims and other individuals who were never charged with a crime and balancing that against the groundswell of public interest to release this information.
How long could this process take?
At the end of the day, the government's motion to release this grand jury testimony is likely to take some time. I think we can expect Judge Berman to take his time to go through the grand jury testimony and to consider what portions, if any, he is going to release. And then even if he does release information, it's likely it will not satisfy the public's desire to get more information about this case because so much of that information is likely not information that was ever presented to a grand jury. It remains in the investigatory files of the DOJ, and the real question is, will that information ever be released?
I guess all you can say is we shall see. Thanks so much, Bob. That's former federal prosecutor Robert Mintz of McCarter English. Coming up next on the Bloomberg Law Show, we'll take a look at the top immigration issues, including the question of whether the Trump administration will be able to deny bond to all migrants who entered the country illegally. That means they could be in detention for months or even years as they fight their deportations. And a federal judge says ICE can't use racial profiling in carrying out arrests. I'm June Grasso, and you're listening to Bloomberg. The city of Los Angeles has been a focus of the Trump administration's immigration crackdown, with complaints that ICE is roaming around car washes, Home Depots, and libraries and targeting Spanish-speaking day laborers for arrest. Here's L.A. Mayor Karen Bass.
When the administration came in, they said that they were going to go after violent gang members, drug dealers, human traffickers. I don't think that's what's happening at a day labor center in Home Depot. You know, how do you go from a drug den to a Home Depot parking lot? That terrifies people, and then they run out chasing them throughout the parking lot.
Well, a federal judge has temporarily blocked ICE agents from using racial profiling to carry out indiscriminate immigration arrests. Joining me is an expert in immigration law, Leon Fresco, a partner at Holland Knight. Leon, before we even get to the legal question, these ICE raids that the L.A. Times reported that ICE agents have been sort of roaming around Home Depots and car washes, stopping brown-skinned Spanish-speaking day laborers and others to arrest on immigration charges. Is this the way ICE has normally operated, or is this something new?
Well, there have been times in the last 25 years that ICE has operated in this way. But if one is looking at the time arc of the last 25 years and said, group them into two buckets, times that ICE has not operated this way and times that ICE has operated this way, over the last 25 years, more often than not, ICE has not operated this way. ICE has tried to go after people with final orders of removal or people with criminal convictions or people in targeted operations where there's something known about the operation, such as that it's a business that exploits their workers or is involved in some sort of trafficking, etc. Now, there have been times, most notably in 2007, 2008, in the last part of the Bush administration, and then beginning points in the Trump administration of the first term, where ICE had started to act in this manner, going around essentially trying to find people it can actually apprehend and place into removal proceedings. And this is the new norm, I would say. It's not something that is very common over the last 25 years, but it is something that is within their mandate. They're permitted to go and try to find people who are not here with status and place them under arrest and place them into deportation proceedings and then actually deport them. Now, the problem is going to be the methods of how ICE operates, and this litigation is very fascinating in that this has been a debate between the pro-immigration enforcement people and the what I would call, relaxation on immigration enforcement people, where they've had this debate about what is it permissible for ICE to do in these operations? Are there limits to what it can do? And that's what was being debated in this case. And I think it's ultimately going to have to take the Supreme Court to adjudicate these issues.
So Tom Homan, the border czar, has said, and echoing what the government attorney said in this case, that agents in deciding whether to stop a person can consider their location, their workplace, the particular work they're doing, clothing, etc. But the judge said that she found a sufficient amount of evidence that agents were using just that, race, language, a person's vocation, or the location they're at, such as a car wash, to form reasonable suspicion. And she ruled that ICE agents can't rely on those factors. Who do you think is right here?
This is the most complicated area of the immigration law that one can imagine, because in every other area of the law, we don't allow our law enforcement to conduct law enforcement based on quote-unquote immutable factors, because we don't like these sort of status crimes. We don't say, go after only this race when it comes to this crime, or go after that gender, or go after people with a certain characteristic. We don't do it. It's illegal. It's not necessary. You can go after whatever the actual violation of the law is. So did you file your taxes? Did you steal from the store? Whatever it may be. So you don't have to do this profiling. And so it's easy to say, if you're profiling, it's illegal, and that's the end of it, because the profiling has nothing to do with the underlying offense. Is the car stolen? Did somebody steal? Did somebody not file some document? Whatever it may be. The problem in immigration is this is a status offense. You're either here legally or you're not here legally. So what are the indicia of a person who's not here legally? It is some of these things. Are you speaking in certain languages versus other languages? Are you engaging in behavior that looks like you're smuggling someone at that moment? That kind of thing. Now, obviously, these things can be taken too far. And for sure, that's the problem, is if you're engaging in this profiling in a way where it's aggressive and it's all over the community and it's everywhere, and anybody who speaks a non-English language to their grandmother who happens to be here legally, but she never learned English for whatever reason, but she's here legally, and now everybody's being arrested because an ICE agent hears somebody speaking to their grandmother in a different language or something, or ICE arrests a bunch of tourists here to see some soccer game or something because they don't speak the language. Just like if I travel to Europe, I don't speak whatever language I'm in my European country. If I'm suddenly being confronted by an immigration officer, those are all tough issues. And so the question starts to become how that enforcement comes into play. What are the constraints? What are not the constraints? And so I think what the group who is suing would say is, ICE, you have to be operating from a list of people you're looking for and go look for them, and then that's how you can enforce immigration law in America. That's basically what the group who is suing is saying. And what ICE is saying is that constrains us way too much because that takes time. And in addition, every time we try to make lists like this, we're being thwarted in various different ways. You know, whether we try to make a list of criminals, the counties and the cities and the states who are quote-unquote sanctuary jurisdictions don't allow us to make a list of criminals. They don't give us the names of people, so they make it harder for us to find those people, so we can't make a list of criminals in these places. If we try to get a list of people who are not using public benefits appropriately, we get thwarted by lawsuits that say you can't do that either. And so this is the problem, is ICE is saying we need to be able to arrest somebody, and if people are making our lives difficult in terms of the effort and the resources and the constraints to make these lists to go find people, then what we'd like to do is to be able to question people essentially when we have a reasonable suspicion that they're not here legally, and ask them to produce identification that says they're here legally. I mean, this becomes super complicated, especially sometimes if you're just a U.S. citizen, let's say going for a jog. You don't have any legal duty when you're a U.S. citizen going for a jog to have any identification on you. But what if that means then you get arrested and you're put in detention for days or weeks until somebody figures out that you're in detention and can find the right document for you? So all of that becomes very complicated and messy. And the courts, I do not envy what they're going to have to try to do to ultimately come to a solution that's reasonable. I don't think the kind of injunction that was issued here will be allowed to ultimately remain in its full form, which is essentially that, I mean, it doesn't exactly say this, but what it is essentially saying is ICE has to know who they're going after before they go after them, meaning they have to say, here's a piece of paper called John Smith. I'm looking for John Smith. I'm going to apprehend John Smith, and I'm going to bring John Smith into detention. I don't think that ICE is going to be limited to just that, but the question is, what is ICE going to be limited to, if anything? And if it's not limited to anything, that will also create its own set of complexities. But I will say this, just if anybody's been paying attention to the Supreme Court over the last 10 or 20 years, they don't like cases where they sort of have to guess something up front and issue an injunction. They like what's called the as-applied challenges, where you can actually go to them and say a certain behavior and then say, is this behavior unconstitutional or not?
The Trump administration says it's going to appeal that judge's ruling, so we'll see what happens there. You mentioned being in detention, and the Trump administration has declared that immigrants who arrived in the U.S. illegally are no longer eligible for a bond hearing while they're fighting deportation proceedings in court. So that means mandatory, indefinite detention for months or even years while the cases play out?
Well, a lot of this is going to depend on the constraints of the space and the funding and everything that's available to detain people for removal proceedings. That's been the reason historically why many more people have gotten bond and have been released and have not been in detention than theoretically could have been placed in detention. But let's start with a more fundamental issue, because this is critically important, which is that immigration detention is not criminal detention. And that matters because the courts have held that in immigration, the people going through this system have far fewer rights than people going through the criminal courts, because it's not a criminal issue. So you don't have a right to a jury trial. You don't have a right to counsel or any of these things. But why does that matter? That matters because since immigration is in the civil context and not in the criminal context, the government's ability to constitutionally detain someone, meaning, keep them locked up, their freedom is gone, is much more limited. And the courts have recognized this, that in the civil context, there's very few reasons to have people in civil detention. And so what the courts have held is that if there's a statute that Congress has said makes the detention mandatory, which is what happens in cases where people have criminal convictions, the only reason that's currently constitutional is if the detention is brief and targeted enough to get you through the proceeding quickly enough. And they have said, come to us with as-applied challenges if the detention is too lengthy in this situation. So now if you're taking it in a context where it's not a mandatory statutory thing, and we know it's not because for decades administrations have said this is not mandatory. This is just now something that the administration is deciding to do. They're saying we're not going to have bond hearings anymore. We're just going to put people in detention. We are taking an optional policy and making it mandatory that people have to be in detention while they're in removal proceedings. At least in the initial hearings, I think courts are going to say that that's illegal and you have to give people a chance to have bond. Just like if you're going through the criminal process, you can have a bond hearing. So, there's plenty of people in criminal proceedings for murder who are out on bond while the murder proceeding is happening, because what you're looking for is the person likely to commit another crime? Are they likely to abscond, et cetera? Is the bond amount sufficient to make sure they'll come? All of those indicia are required also in the immigration context, and even more because it's a civil detention, which really is not something that the law is very fond of, as opposed to a criminal detention. And so, at least in the lower courts, I think this is going to be very tough for the administration to put this policy in place once the lawsuits get filed and rolling. But then again, it's going to go up to the Supreme Court, and the Supreme Court is going to have to decide, does the administration have the ability to just change from, the previous 25 years, the norm was people who didn't commit crimes could get bond hearings where a judge would decide, hey, can you be constrained by a high bond and other things such that you're not dangerous, you're not at risk of absconding, or do you have to be placed in detention, as opposed to just taking away this ability to give people bond hearings whatsoever, which is what this policy does. We will see what the Supreme Court does, but in this context, the Supreme Court has only allowed it because it was congressionally mandated. It involved criminals, and it was for a short period of time. If this is going to be many, many more people and non-criminals, and it will be much lengthier because you're putting more and more people into a system that still, at the least at the moment, has the same amount of immigration judges, which means that just makes every case longer because you have more people going to the same number of immigration judges. I don't know if the Supreme Court is going to allow it, but again, we'll have to see if they put any constraints on it in advance, or do they make it again an as-applied challenge where people have to come in, let's say after 6 months or after a year or after 18 months and say, hey, I've been detained too long while my removal proceedings are pending, let me out. That's what we're going to have to wait and see.
Coming up, a lawsuit over ICE agents arresting people outside immigration court. This is Bloomberg. I've been talking to immigration attorney Leon Fresco of Holland Knight about the Trump administration declaring that immigrants who arrived in the U.S. illegally are no longer eligible for a bond hearing as they fight deportation proceedings in court. Leon, the Department of Homeland Security said that they revisited their legal position on detention by reinterpreting an immigration law from the 1990s. So they're saying that under Section 235, which says shall be detained, they're saying that the interpretation before was inaccurate and it means must be detained.
Right, and shall be detained means for the purposes of putting them into removal proceedings, meaning what the statute says is ICE or Department of Homeland Security, if you find someone who's undocumented, detain them, place them in removal proceedings. But it doesn't then say what you do with them after you've detained them and placed them in removal proceedings. Can they get out on bond or can they not get out on bond? And for the last 25 years, that answer has been they can get out on bond. And the reason it has been that they can get out on bond is for the reasons I'm saying, which is that because the Congress didn't specifically say, like it did in the criminal context, you can't release them. So here, there is no such statute that says you can't release them. So you have to say that if Congress has a statute in one context that says you can't release them, that means that in this other context, you probably can release them. This is going to be the question for the court, is can the government constitutionally, in the civil context, decide to not let people have the right to a bond hearing while their immigration proceedings are pending? And that's why the policy has been what it's been the last 25 years, is nobody thought that the government could get away with this. But we're going to see. We're going to see what the courts say. I don't think the lower courts will be friendly toward this position, especially in the jurisdictions where it's likely to be challenged. But it's possible the Supreme Court will say, as they've been giving deference in some context to the Trump administration and immigration recently, that they are permitted to hold everybody in detention that's in the removal process. And then it will just be up to the constraints and the number of facilities that the Trump administration has. So that's what we're going to have to wait and see. But whether this detention is constitutional or not will depend on a number of factors, which also include how lengthy is the detention going to be, and are these people really demonstrated to be flight risks, et cetera. And all of this is going to be litigated in the court.
Speaking of litigation, so as we've discussed before, ICE agents, and this has gotten a lot of publicity, ICE agents have been arresting migrants who appear at immigration courts for previously scheduled hearings. The government will dismiss the deportation proceedings, and then when the migrants leave, there are ICE officers waiting in the hallway to take them into custody. So a group of immigrants and legal advocates filed a class action lawsuit last week to stop this. What do you think about their chances? They're saying they're stripping them of rights afforded to them under immigration law and the Fifth Amendment.
This is another of these very complicated cases, both policy-wise and legally. Policy-wise, because, again, this is a place where ICE would say, fine, you don't want us racial profiling, going to the Home Depot, grabbing people in the middle of the street. Here's one of the easiest places for us to apprehend people and place them into detention, which is in the immigration court. They've already cleared the security. They don't have any weapons, et cetera. And you don't even want us to do this. That's what they would say from their perspective. The people representing the foreign nationals would say, wait a second, these are the people who are following everything correctly. They're actually showing up to their court hearing. They're not absconding. They have a process. You just don't like how long the process is going to take with these individuals. So you want to place them into an expedited process. And by the way, the end result of placing them in this expedited process is that maybe 70 or 80% of them, after 3 or 4 weeks of detention, will go right back to the exact scenario they were in previously, and only maybe a fifth or a quarter of them will be able to be detained and deported on an expedited basis because they won't be able to meet the initial threshold of even having a credible asylum claim. So, yes, some number will. And then the question is the juice worth the squeeze there? And that just will depend on where you're looking at it from. From the perspective of ICE, if that's an extra 50,000 people they can deport in a year, they might say that's very worth it to us, especially since we didn't have to go into the community and have guns blazing and have armor and all of this. But from the perspective of the immigrant rights community, they would say, yeah, but now no one is showing up to court. And the whole point is you wanted people to show up to court. They had a case. They were making their case. Now they have to make a different case. You're violating their due process because you're making them change the case that they had for no good reason. This is, I think, another case where I think there's likely to be success in the lower court, but I think the Supreme Court likely at the end of this probably stays any injunction. And behind the scenes, what I think they would be debating and contemplating would be some sort of context where they say ICE has to be able to arrest somebody for something, and perhaps this is better than the Home Depot scenario. And so this is where I think these practical realities start colliding with the law. And certainly you wouldn't want to design a framework where people were terrified to go to immigration court because something bad was going to happen to them even mid-process. So the point is, yes, they may know that at the final hearing they will either win or be deported. Fine. So that there's always that. But mid-process, when you don't even think you have any fear of being deported, the fact that you would go to court for a check-in hearing and be placed in detention that same day, I think that's alarming to people. And if the result is that people stop going to court because of that, then there can be perhaps a claim made that this is encouraging people to basically end up having in absentia removal orders, because that's what happens when you don't go to court, is you automatically forfeit your case and you can be removed because you were in absentia. You didn't show up to court. And so that's going to have to be the argument that's made, and we'll have to see where the courts come out on this.
Leon, it seems pretty clear at this point that they had said they're going to arrest criminals first. They're arresting the worst of the worst. They're not arresting the worst of the worst, or even those with criminal records. The latest ICE statistics show that as of June 29th, there were 57,861 people detained by ICE. 71.7% had no criminal convictions. Why are they not going after the criminals first, as they said they would?
It's very hard. It's very time-consuming. It's very resource-intensive. If they go to somebody's house with a criminal conviction, they don't show up with just one ICE agent, as you've been seeing. They show up with multiple agents. They show up with a warrant. All of that takes time and effort and energy to do. And when they have one of these huge operations that they publicize, it maybe captures 250 people, and it took many, many agents over many, many days. And so it doesn't yield the kind of numbers they're looking for. They're looking to try to arrest 3,500 people a day. And if you are trying to arrest 3,500 people a day and get, into a scenario where you're over 1 million people you're deporting in a year, then the only way to accomplish that is to try to arrest people without criminal convictions that you can find in other locations, such as ICE check-ins, courts, or people who were here legally, but their status expired because they came in under one of the statuses that the Biden administration created, which were, again, these are debates about whether those statuses were proper to create or not. But the point is, these people are well known. They're out in the open. They were here legally, and they're the easiest to apprehend. And so you do have some segment of the restrictionist individuals who say, that's the people you should be going after. You need to get deported every single person who came in under the Biden administration, whether they came in illegally through the border or through one of these programs. And I think ICE has taken that rhetoric seriously, and that appears to be the large segment of who they're looking for are the people who enter, be it illegally or legally, during the Biden administration, in addition to criminals. But again, as you pointed out, not the majority of criminals because of how resource-intensive that process is.
At this rate, they're not going to reach their 1 million deportations in a year.
Well, at this rate, that's true, but they just over the last month been given $40 billion, which is going to take a while to ramp up because they're first trying to bring back agents that had retired. So that's the first thing they're trying to do. Then they're going to have to hire new agents. When they did this with the Border Patrol under the Bush administration, they had a lot of problems hiring people who didn't have criminal convictions and weren't otherwise employed in the marketplace. This is not the easiest job to recruit people for, because people understand when they sign up to become ICE agents, it has a certain wear and tear to it. So it's not really the easiest job to recruit for. And so from that standpoint, all of this is going to have to be brought up. But as these agents and resources start getting brought up, you will see the numbers get higher. But then the question is going to be, fine, as the numbers get higher, now what? And that's where the society starts pushing back. And you're starting to see this on that front, too. So there's the resource constraints on why the numbers are low. Those are going to be taken away soon, and the resources will permit higher numbers of removals. And then the question is, when that's actually being implemented, what's that going to look like and feel like in your average big city? And is there going to be the level of pushback where the president himself is getting contacted by numbers of people saying, hey, I know you're deporting XYZ, but don't deport my person, and he keeps hearing that over and over again, and everybody has a person that they care about, and now suddenly, it becomes a process where the exceptions swallow up the rule, and that's where we're going to have to wait and see what happens there.
Yeah, and more Americans are souring on Trump's immigration crackdown. According to a new CBS News YouGov survey, only 44% of Americans approve of Trump's handling of immigration. 56% disapprove. That approval rate is down 10 points since March.
Obviously, everybody debates who's polling what and who's getting polled and everything. But just in general, it's fair to say that the ramifications of large-scale immigration enforcement to the level that's being contemplated by the administration, because people haven't actually lived through it and seen it, there are going to be, just because it is inevitable, things about that process that make people uncomfortable, and we're going to have to see where the societal alarm bells are.
Thanks so much, Leon. That's Leon Fresco of Holland Knight. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.